Helping Seniors Television, all about improving quality of life for seniors. If you're a senior, know a senior, or plan to be a senior, then this show is for you. It's all about helping you develop your own aging plan so you can age actively and with dignity. Helping Seniors Television from the Helping Seniors Network of information, education, and resources. Welcome to Helping Seniors Television. This is the show from the Helping Seniors nonprofit. We're here to educate, inform, and connect seniors and their families to the resources and information that's going to help make a difference in what Joe Steckler, our chairman, emeritus, and founder, has always said. You need an aging plan. As you get older, we understand, we live here in Florida, so we understand what they talk to us about hurricane plan. It doesn't mean you want a storm. It just means you want to have a plan of attack and you know what you're going to do and you know how you're going to stay safe and survive it. And that's a little bit what we're talking about with when we talk about making an aging plan. We call it euphemistically getting your ducks in a row. And we have somebody that's really an expert at helping us get ducks in a row with us today. It is none other than board certified elder law attorney Ruth Rhodes with the law office Rhodes Law PA. How are you, Ruth?
I'm doing good, Kerry. Thanks for having me.
You know, this is so, I learn something every time we sit down, and I'm excited to have the conversation today about estate planning. And I know it's kind of maybe a weird thing to say, excited to say, because it's one of those things that if you really love and care for your family and you really want some peace of mind, this is something you really do because it helps you in both levels. Am I saying that the right way?
I think so. It does. It gives you peace of mind knowing that you have a plan in place to help your loved ones get through a process if you're not there to help them.
Yeah.
And it helps your loved ones know that there's a plan, right? For a couple of reasons. If you have a written plan, it helps with, I think, keeping family fighting down.
Yeah.
If your intent is very clear and in writing, I think it helps with that. It also, depending on what kind of plan you set up, it can make it very easy for the person you leave behind to maneuver it.
There's no question about it. I was thinking, even as you were saying that we live in an age where there's so many blended families. Somebody may have been married a couple of times and there's kids from, and all these different things. And I was thinking, like, we laugh about this. In fact, we talked about this in a previous episode that we had the privilege to tape it together. We said, well, if you don't have a plan, the government has a plan. Mm-hmm. It just may not be the plan that you had in mind. And I was thinking, boy, that really comes to mind when we're talking about your wishes about how you want to see things go if you're not here to do that, right?
Oh, absolutely. And if you don't have a plan or you have a failed plan, especially with blended families, you could accidentally or inadvertently disinherit your own children.
Wow.
If you don't set that plan up right.
That's the thing we don't think about, because if the state has a plan and it follows certain rules, like if this person's married to this person and then they have these children and all that, there's a whole structure for that. It just may not have anything to do with the reality of what you would hope happens, right?
Right. Exactly. And all the more reasons why I preach, so do you, about making sure you have a plan. And it needs to be done properly in the form of legal documents that are witnessed and notarized and all the I's dotted, all the T's crossed, because if you don't have a plan, then the Florida statutes has a plan for you. And that may not have the outcome that you had hoped, had you done your own plan. And
you mentioned this already, but I just want to hit on this again because it seems so important, is that actually you're doing a good thing for your family by putting together this plan, because you're making what you want to have happen clear, as opposed to leaving that to be open by interpretation. And most kids can't even get together at a family reunion and agree on where they want to go to lunch, let alone if it's something that's really important, like, well, Dad wanted me to do this and he wanted you to have that, and everybody has a different viewpoint on that.
Absolutely. And what's funny or not funny is the childhood issues that people had with their siblings growing up. It doesn't go away really, and the worst of it will come out when mom and dad are either mentally failing, and there's a power struggle, or they've passed away and now they're fighting over what's left. And I have had clients that are in their 60s, well into their 60s, that are still talking about things that happened when they were 5. because of a sibling, and they hold grudges.
Wow.
So I just think that for peace in the family, mom and dad should have a very clear, well-written plan.
Yeah. So now if we get into that, that is what we're talking about today, estate planning. And you take us down a couple of different paths. There's a thing called probate, which I guess is part of what we need to understand. And then there might be a thing called trust, which is a part of how you might think your strategy goes. Where do we jump into all this conversation?
Okay. Well, I think a lot of people have heard the term probate. So maybe that's a good place to start.
Okay.
So probate is actually a court administrative process. It involves a court case, and it's needed in the event that there's assets that need to be transferred that won't otherwise transfer without the assistance of the court. And then there's a couple of different ways of doing it. Either the probate is going to be called like an intestacy, which means that they will be following the intestacy statutes, which means they don't have a will, right? They don't have a will, so it's going to be an intestate. Or they do have a will, and we're going to be following the will's instructions through the probate, and that'll be called a testate probate. And then there's several different ways of doing probate in Florida, depending on the value of the estate, whether it's going to be a very simple distribution where there's very few assets, or a summary administration where there's assets but it's less than 75,000, or a formal administration. And just depends on, a lot of times it's going to depend on the value of the estate. So if it's over 75,000, we already know it's going to be a formal administration. If it's a situation where you need a personal representative to be appointed, then we know it's going to be a formal administration. An example of that would be there's a wrongful death suit, and the estate is suing on behalf of the person who passed away for wrongful death or injuries. There has to be a personal representative appointed to have authority to negotiate, to sue, to settle. And that would require a formal administration. And the difference is with formal versus summary admin would be the length of time, the complexity, and the cost, especially the cost. Yeah.
So I know generically, because I've heard this enough, that if you can, you do want to avoid probate. And I've understood it to be on a number of reasons, that it's a costly procedure. It can slow things down, take a long time, because everything, once again, you're going through courts, and everything moves just at that pace, right?
Right.
And so when we're thinking about estate planning, we're really trying to think towards, how do I not have to jump through all those hoops, right?
Right. So when I sit down with someone in an estate planning consultation, I'm thinking of a couple of things. Thinking, how do I take care of them if they lose capacity? And how do I help them distribute their assets and take care of the loved ones after they pass, and hopefully be able to avoid probate, especially if avoiding probate is important to them. So whether a probate's going to be needed, a lot of it depends on how you set up your assets, and whether there's going to be a beneficiary. So you can avoid probate oftentimes with bank accounts by making sure there's a beneficiary named on the account, but that may not have the outcome you want. So if you say you give the money to one child, and you say to that child, I want you to share with your siblings, or you add a child on as a joint owner onto the account, so they end up owning the account when you die, and you say, I want you to share with your siblings. Well, there's nothing to require that. And although we want to trust our children and want to think that they're honorable, it happens frequently enough that the honor's not there, because money does things to people sometimes. And I wouldn't want to put my child in a situation where they're tempted. I would want to make it clear and make my plan clear for them, so that there's just no question, this is what you need to do. I would never recommend putting a child on or trusting someone to do the right thing with the money.
Yeah. I was even thinking about that. I've heard it explained before, like even if you put your child onto a bank account or something like that, and they put them on while you're living, then all of a sudden, not only could it create problems like we've talked about before, if you're thinking Medicaid planning or things like that down the road, but also it puts you subject to whatever's going on in your child's life. If there's a car accident or something happens, and now that money is part of whatever's going on with them, and it may not even do what you had in mind, which is, again, back to the point of why we want to get this set up the right way to begin with.
Right. I am not usually going to ever recommend adding a child onto any assets because you are correct. If that child goes out in the car, hurts someone, gets sued, or gets sued for debt they owe and they go to collect money, they're going to look at all the assets.
Right.
And if they're named as an owner on your bank account or an owner on your house, then now you're in a position where you have to defend them being able to collect from your assets.
Yeah.
So there's better ways to avoid probate than to add a child onto an asset. There's much better ways. And you're right. If you add a child onto an asset, that could have negative consequences when it comes to Medicaid planning and whether or not you'll be able to get Medicaid or have a disqualification period for Medicaid down the road.
Yeah. So if we're talking about, I think the word that we're going to move ourselves into, I know there's different terms that I've heard elder law attorneys speak to before. You can have, like if you go in and open up a bank account, they say, do you want to pay it on death or there's a TOD, I'm not sure. But I've heard those terms. But then if you get down to like houses and businesses and cars and different things that you might own, this is where a trust, is that where you want to start having discussions about all of that?
So a trust could be very helpful for avoiding probate. It's also a good tool for avoiding guardianship as well, but it's really good for avoiding probate. It can be used to take assets that the trust owns and distribute it in the manner that you wish it to be distributed without having to go through the court process, which is good because your affairs then stay private.
Right.
And whereas probate is potentially public. Can just any old person log on and look at your stuff? Maybe, maybe not, but it's technically public record. Yeah. So you're at risk for people to be able to see your filings in the probate. Where if you want things to stay private, you do it through a trust. And you can use the trust to avoid probate for that purpose. And you have a lot more control, I think, too, with other things. Like, for example, if you wanted to leave money to a disabled child who receives some kind of benefits, Medicaid benefits themselves or SSI, you could do it through your trust using a special needs trust built in for them. That way they can receive the benefit of inheriting from you without disqualifying them from receiving benefits themselves.
Right.
Also, a trust is great for if you want to leave money to a child that's under 18 and you want to avoid a guardianship for them, because I mentioned earlier that if a child under 18 inherits $15,000 or more, a guardianship may become necessary, whereas a trust would avoid that guardianship.
Yeah.
One other thing that I want to mention is pet trusts.
Yeah.
Pet trusts, right? Whose fur baby is the most important person in your life? No, I don't want to say that. I have a husband and kids, so I love you guys. But I also have a fur baby, right? And who's going to take care of my baby?
You know, I have to interject and say, you know, it was so funny during the COVID days when everybody was locked down. I was really surprised. You probably would not be, but I was really surprised how many people started calling the Senior Information Helpline, and they were concerned about getting out to the grocery store, but not so they would feed themselves. They needed to feed Fido. And this is really serious for people. This, you know, so talk about this. How does that work?
The pet trust, pet trust. There's a couple of different ways of doing pet trust. You can do an independent standalone trust that becomes an effective trust right now. Yeah. And you can fund it with assets right now. Or you can set up a trust within your own trust that will take effect upon your passing to take care of your dog, your cat, whatever pets you have. So generally, you can set it up to take care of the pets that you own at your death. and it will stay active and take care of all those pets through the life expectancy, or through the end of the life of the last to survive, right? So you may have 5 cats or 5 dogs or whatever, horses, birds, fish.
Sure.
So the trust will stay active until the last pet dies. It does not do generational.
Yeah.
So
it's not like
so they're not going to be able to have a litter of puppies and it gets to continue on. So like Bob Barker said, get your pet spayed or neutered. Right. But it'll take care of them through their life, and you can fund it with assets, and you can put someone in charge of the care of your pet, and then someone in charge of the money. And I like to divide it up because there are terrible stories out there about people who are left the pet and left a gift, and then they put the pet down, keep the gift. It's nasty. So I like to divide it up. I like one or two sets of successors, of people who are willing to take the animal and care for the animal and love the animal. And then I want someone else who's going to have the money and they can have oversight. And then one more layer of protection I like is at the end of the last of the pet's life, right? When they're all passed away, who gets the money? Not that caregiver, right? Because that gives them an incentive to put the pets down.
Sure.
Not the trustee, because that gives them an incentive of being cheap and not buying what needs to be taken care of, right? I would suggest giving it to someone completely different. And I usually like to say, hey, how about a animal shelter? How about a no-kill shelter?
Sure.
You know, leave it to them.
Yeah.
I mean, if you're a pet owner and you're an animal lover,
sure,
that's a good idea.
No, it's so many angles and things to think through. Now, if somebody sits down, I always used to have this line that I thought, because I remember this from the Beverly Hillbillies theme song of the TV show from the 60s, and they would sing about swimming pools and movie stars. And I always thought, I think most of us grew up with the idea that trusts are really only for rich and famous people. We got estates in all these places and all these things. But I've come to understand that it's probably a vehicle most of us need to consider.
Yeah. I mean, trusts are not just for rich people. And maybe there was a time when that was more for rich people, but now it's used for a lot of people. And if you own a house and you want to avoid probate, a trust may be a great way to do it. There's another option. It's called the ladybird deed. Now, every time I mention that, people are like, what? What is this ladybird deed you talk about? And it's also known as a poor man's trust because it doesn't replace a trust, but it could be an inexpensive way of leaving a house or real estate to a person. If you have one person that you would like to leave a house to or other piece of real estate, then a ladybird deed may be the answer to do that.
Wow.
But if there's any concerns about, will this property disqualify them from getting benefits, or will this? So some people, I've actually had people come in that had ladybird deeds drafted by other attorneys, because I would have probably said, no, don't do this. Where the ladybird deed is being left to 6 children.
Oh.
And the problem with that is you just gave a house or real estate to 6 children. And if they don't all agree on how this property should be handled, then pretty much you're guaranteeing they're going to have a litigation problem. Because there's always one that are like, no, I want to Airbnb it. And there's one like, no, I want my money. Let's sell it. Let's get the money out. And so it's hard to, get 6 people on board. So I talk to my clients first if they're interested in that kind of a situation, like a ladybird deed versus a trust. I'll ask them, how many people are you going to leave this property to? And they better get along like peas and carrots, because otherwise it could be a problem.
It's so interesting because there's really so many dimensions to this. And I think as you explain this, it's why a little knowledge is such a dangerous thing. If we think we have like, oh, okay, I have this idea about how this should work, but we probably typically don't even necessarily know even the right questions to ask, which is why I assume that if someone comes in and sits down at your office, because of your experience and the fact that you've done this and you're board certified elder law attorney and all just the experience you have, you know the questions that we need to consider so that you can help us formulate the best plan given our circumstances.
You know what's funny, Kerry, about what you just said is when I meet people for estate planning, they have a concept and an idea of what this is about.
Yeah.
And when we're done,
totally different.
Yeah. The comment frequently is, my goodness, I didn't know this was as complex as that, because it is. It's it's deceptive. It seems so simple, but it really is complex. And I have seen both ends. I know the estate planning process,
right,
and I know what the other side looks like, whether you planned correctly, didn't plan well, dealing with the fighting siblings, dealing with upset, angry beneficiaries, and dealing with happy ones that are like, this went really well because my mom or my dad really did a good job planning this.
That's also a fascinating part of the whole conversation, is because, again, when you take the time to do this and set this up the right way, then you really have like a peace of mind of knowing that what you had in mind is going to actually be there for you when you need it to be. And that's why I always laugh. We've talked about this in many episodes, and when we've done radio or print articles or different things where we've tried to share this information, it seems deceptively easy. They show you a TV commercial, oh, just a few clicks here, and your will be done. And I know we've talked about it, but even just with the little bit of knowledge I have, that looks very scary to me, because you don't know that it's going to work until you need it to work. And you made a comment in a recent, you gave a presentation here at the Senior Resource Center, and you made a comment that you have really yet to see one of those go the way it was intended when it actually has to work.
Well, mostly with that power of attorney, but oftentimes too, even with the wills. The unfortunate thing is when you do your own documents or you download them from the internet, or if you go to a paralegal service that's not ran by an attorney, is you're not able to get the legal advice, or hopefully they're not giving you unlawful legal advice, right? But you're not getting the legal advice. So you can click here, click there, but how do you know those are really the right choices for you? And they're not allowed to give you advice.
Right.
They can say, if you click this, this is what that means, but they can't really say, well, in your particular situation, this is how this may look.
Yeah.
Right. So the legal advice is invaluable. And that's why it is important that if you're going to do estate planning, that you have an experienced estate planning attorney or elder law attorney help you.
Yeah, that's the other thing I was going to bring up, is that you really need to go. You might have a family attorney that you like and has helped you with different matters along the way or something, but that doesn't mean it'd be like going to a podiatrist when, your general practitioner says you need a cardiologist. You got to get the right person with the right expertise on this. And this is probably like the biggest, if you think about it, this is probably the biggest and most important category in your whole life. I mean, almost anything else would seem like small potatoes compared to getting these kind of paperworks right, because everything flows from it. If you need the Medicare help, if you need the estate plan, you want to be sure things are being distributed correctly, and you're not losing all the money and court costs and attorney's fees and squabbling and all that. You have to do this right from the get-go.
Absolutely. And your estate planning documents are so important, because not only all those things you mentioned, but think about this. When they become active, when you begin to have to rely on them, you are at your most vulnerable in your life. You are. And it's important that those documents be well written, so that they do what you expect them to do. And when your family needs to use those documents, either because you've lost capacity or because you've passed away, they're dealing with a lot of stress. We help families dealing with that kind of crisis all the time. It's hard, whether they're helping someone try to qualify for Medicaid, or whether they just lost their loved one and now they're just trying to figure out how do I get through the labyrinth of all of this? Because it's confusing. And as a society, I don't believe that we get enough education on end of life things. What Helping Seniors is doing is so wonderful because you are pushing this out there. You're educating we're reaching the masses.
Exactly.
But other countries do a much better job, like Sweden, for example, do a much better job with being very realistic on end of life planning. And, we're not doing a good job here, but Helping Seniors is really putting a dent in it.
No, that's been that's been Joe's point of view since the day he started this. And as we're talking today, we're like starting in on 15 years of Helping Seniors. But that's what he said the day I met him, when he had built up the Brevard Alzheimer's, kind of stepped away from all that, couldn't stay retired. And I remember him saying, he said, a lot of seniors have cognitive challenges. He said, but every senior runs into these challenges that life throws at them. And they always say, you have a plan for everything. Mm-hmm. When you're in school, what do you want to be when you grow up? When you're an adult, well, what are you going to do? Are you going to have kids? Are you going to college? What are you going to do? What's your job going to be? And then even when you're older than that, they say, well, what's your retirement plan? And they're talking about how you're going to save. What are you going to, right. But he says you got to have this aging plan. So Ruth Rhodes, board certified elder law attorney, if somebody wants to get in touch with the office and chase down, it's time to get serious about estate planning, how do they reach you?
Well, first off, Kerry, I always do free consultations when it comes to estate planning. I think that's very important to have that conversation. Yeah. So I don't charge for the conversation. But if you want to talk to me or one of the attorneys in my office, my telephone number is 321-610-4542. That's 321-610-4542. Or you can log on to the website. You can contact us through the website, and that is www.rhodeslawpa.com. That's RHODESLAWPA.com.
All right. Well, thank you, Ruth, for joining us. And thank you, viewer, for tuning in to Helping Seniors Television. We'll see you on the next episode.
I'm Joe Steckler. Thank you for joining our program today. I'd like to remind you that our senior information line is available to you at 321-473-7770. There you can get help and direction that could be helpful for your specific situation or circumstances. The work of helping seniors is very important, but we can't do it alone. That is why our sponsors here in Brevard County are so important. I'd like to thank our many area sponsors, businesses, and medical providers who support the mission of helping seniors that help us carry the cost of our media efforts. If you'd like to join us either as a business partner or simply donate as an individual, we welcome your call at 321-473-7770. You are always welcome to visit our website at www.helpingseniorsofbrevard.org. Thanks so much for your help. It does make a difference.